Hello everyone and welcome back to the channel The Law Guide. This is the second part of the topic powers shared between center and state. In this video we'll discuss from article 250 to 255, so stay tuned. Also, if you haven't watched the first part of the video, please click on the link mentioned in the description. So let's begin. So, starting with Article 250 of the Indian Constitution, this article gives the Parliament the power to create laws about any subject that is listed under the authority of the states when there is a state of emergency declared. This means that during an emergency situation, Parliament can pass laws that affect the entire country or just a specific area. However, it is important to note that once the emergency is over, any law created by the Parliament becomes invalid after 6 months unless certain actions were taken based on that law before the 6-month period ended. In other words, the laws made during an emergency have a limited duration and are no longer valid once the emergency situation is resolved, unless they were already put into action before the time limit expired. Now, Article 251 of the Indian Constitution deals with situations where there is a conflict between a law made by the Parliament and a law made by a state legislature. According to this article, if there is a clash between a law passed by the Parliament under Articles 249 or 250, which give Parliament certain powers during emergencies, and a law made by a state legislature, the law made by the Parliament will have the upper hand and take precedence. This means that the Parliament's law will be considered more important and will be followed over the state's law. However, it's important to note that the state legislature still has the authority to make laws within its own powers. But if any provision of the state's laws contradicts a provision of the law made by the Parliament's law will be given more importance and the state's law will be ineffective as long as the Parliament's law is in effect. This ensures that in cases of conflicting laws, the national law holds more weightage and prevails over the state law. Article 252 of the Indian Constitution deals with situations where Parliament wants to make a law that applies to multiple states on certain matters. Here's what it means. Number 1. Parliament can pass a law to regulate certain matters that affect 2 or more states, but it can do so only with the consent and adoption of that legislation by the concerned states. This means that the states involved must agree to let Parliament make a law on that particular matter. Number 2. If the legislatures of multiple states pass resolutions in favor of allowing Parliament to regulate that matter, it becomes legal for Parliament to enact a law on it. The law will apply to the states that consented to it as well as any other state that later agrees to adopt it through their respective legislatures. So, additional states can join in later if they want to be a part of the law. It's important to know that any changes or cancellations to the law can only be made by the Parliament itself. The legislature of any state to which the law applies does not have the power to amend or repeal it. This ensures that the law remains consistent and is not subject to changes from individual state legislatures. So basically, Article 252 allows Parliament to make laws that regulate certain matters in multiple states, but only with the consent and adoption of the concerned states. Once the law is enacted, it applies to the consenting states and any other states that decide to adopt it later. Parliament retains the authority to make changes to the law, while individual state legislatures cannot modify or remove it. Article 253 of the Indian Constitution gives the Parliament the power to create laws that are needed to follow international agreements, treaties, conventions, or decisions made at international conferences or organizations. This means that if India has made commitments or promises to other countries or international organizations, Parliament can pass laws to fulfill those obligations. These laws can apply to the entire country or specific regions of India, depending on the nature of the commitment. The purpose of this article is to ensure that India complies with its international agreements and obligations. Therefore, it allows Parliament to make necessary laws that align with the requirements or rules set by other countries or international bodies. So, in a nutshell, Article 253 empowers Parliament to create laws that are necessary to implement and fulfill India's commitments to other countries or international organizations. These laws can be applicable to the entire country or specific regions as required. Article 254 of the Constitution addresses situations where there are conflicting laws made by the Parliament and the state legislature. Here's what it means. Number one, if there is a contradiction between a law made by a state legislature and a law made by the parliament, and both the laws pertain to a matter that falls within the parliament's authority, then the law made by the parliament takes precedence and becomes the valid one. This means that the state law has now become void and ineffective. However, there is an exception to this. If the state law has received the President's assent, which means that it has been approved by the President of India, then it can remain valid and prevail within that particular state. The President's assent gives the state law the power to override the Parliament law on that specific matter. Additionally, Parliament has the authority to modify or cancel any state law related to the same matter. This means that Parliament can amend or repeal a state law if it deems necessary. Last, we come on to Article 255 of the Constitution, which deals with situations where an act of Parliament or a state legislature or any provision within it does not receive the recommended or previous sanction as required by the Constitution. Here's what it means. If an act or provision within it does not receive the recommended or previous sanction as required by the Constitution, it will not automatically be considered invalid. In other words, the act will still be legally valid if the appropriate authority has given their assent to it. The assent can be given by different authorities depending on what the Constitution specifies. It can be given by the governor, the president, or the Raj Pramukh, depending on the specific requirement mentioned in the Constitution. This article clarifies that recommendations and previous sanctions are considered matters of procedure. This means that if the authorized entity, that is the governor, president, or Raj Pramukh, gives their assent to the act will not be invalidated just because it didn't receive the recommended or previous sanction. In summary, Article 255 states that if an act of Parliament or a state legislature or any provision within it lacks the recommended or previous sanction required by the Constitution, it will still be considered legally valid if the assent is given by the appropriate authority. The specific authority that can give the assent depends on the provisions mentioned in the Constitution. The article clarifies that recommended and previous sanctions are procedural matters and do not render the act invalid if the authorized entity provides their assent. And that's a wrap for the topic Powers Shared Between the Central and the State video. I hope you found this breakdown of the distribution of the powers between the central government and the states informative and engaging. If you did, don't forget to give it a share with your friends.